Excellency, may it please the court. I am Carmen, and I'm appearing alongside my co-agent in this case, Ms. Divya. We have the honor to appear on behalf of the applicants, in this case, the State of Eurasia, and my learned agents for the respondents, the Republic of Ronoval, Mr. Kishan and Mr. Martin. I will submit first for 15 minutes, and Ms. Divya will submit another 15 minutes, and we reserve 5 minutes for rebuttal. Your Excellencies, I will be submitting that the St. Pierre Island belongs to Eurasia, and that Imaru can intervene in the case between Eurasia and Ronoval. Ms. Divya will demonstrate that Eurasia is not liable to compensate the respondents for the damage suffered by the HMS Gong Hippo and the HMS Long Genie. Before I begin with my submissions, would Your Excellencies like a summary of the facts?
For me, it's okay.
I think it's all right. We have the facts. You can proceed.
Much obliged. I will now begin with my submissions proper. The applicants would like to first submit that the St. Pierre Island belongs to Eurasia. We submit two major bases for this. First, that the St. Pierre Island legally belongs to Eurasia, pursuant to the United Nations Convention of the Law of the Sea. Article 3 of the United Nations Convention on the Law of the Sea regarding the breadth of the territorial sea states that every state has the right to establish the breadth of its territorial sea up to a limit not exceeding 12 nautical miles, measured from baselines determined in accordance with this convention. If I may, I would like to request for Your Excellency's attention to refer to the Statement of Facts, page 7, paragraph 6, line 3. Here it states that the St. Pierre Island belonged to Eurasia. As both St. Pierre Island, as both Eurasia and Ronoval are states which are parties to the United Nations Convention of the Law of the Sea, they are both bound by it. Pursuant to the convention, Eurasia has the right to establish that its territorial sea is within the limit of 12 nautical miles. It is also a fact agreed upon by both parties that the St. Pierre Island is within 12 nautical miles of Eurasia. Thus, as it does not exceed the limit.
Agent, before you proceed, you mentioned a rule established on the United Nations Convention on Law of Sea. This rule, do you understand that is a rule recognized by the customary law?
Yes, Your Honor. Yes, Your Excellency.
So how we can see the opinion juris and the state practice of this customary law?
This law can be seen, the customary law side of this convention can be seen in the case of Batu Putih, pardon me, it can be seen in the case of Malaysia and Indonesia concerning the sovereignty over Pulau Digatan and Pulau Sipadan in 2002. In this case, they did mention the customary law part of the ownership of this island, of these islands.
Agent, but concerning this case from the Pulau Island, if I'm mistaken, there is a dissenting opinion from Judge Dugard from the International Court of Justice stating the difference between ownership and sovereignty. Do you agree with this distinction, and this distinction can be applied here in this case?
Yes, Your Excellency.
I think you should refer to the Sepute case, because the Likitan's case is actually on intervention. Yeah. So okay, I'll let you answer, Judge Imonis.
Much obliged, Your Excellency. Thank you very much for your correction. Yes, so in regards to the ownership and sovereignty over the island, yes, we recognize and we understand that there is a stark difference between the two. However, it is this point that we are making right now is something that must be taken into account as well when we are talking about the sovereignty of the island.
Okay.
Hope that
May
answers the
proceed.
question, Your Excellency. Thank you very much. So,
Basically it's factual, right? The
yes, Your
ownership
Excellency.
is basically, so can you identify the timing of dispute? When, I mean, the, how you call it, when did the dispute, when was it contested, and the events prior to determine the stake on the island, sovereignty as opposed to ownership. Do you understand the question, Carmen?
Yes, yes, Madam President, I
All right,
understand.
yes.
It is stated in this case that this was an outstanding issue that has existed between both parties. However, the year, the exact number of years that both the respondents and the applicants have been claiming ownership over the island is not specified in the statement of the facts. In this case specifically.
There was a 58 years of uninterrupted administration in reference to the helipad.
Yes,
and the
Your
lighthouse.
Excellency. Yes, Your Excellency. That is the number of years that has been claimed by the respondents to have been administering and taking care of the helipad and the lighthouse that they have established on the island. This will lead to my second basis for our
And
submission.
then the issue across on the 12th of October, right? The incident, like no.
Your Excellency, on 12th of October, the incident that occurred was that a naval ship belonging to Ronoval has decided to chase away the fishermen of AirAsia. This was the trigger that decided to cause the citizens of AirAsia to protest and cause an uproar.
So before that period of time, was there any protests? Was the fishermen's always in that 53 year always fishing in that area? Oh
yes, yes, Madam President. This area has been constantly claimed by AirAsia. The fishermen have been fishing there for 53 years. And Ronoval has claimed that they have, at those 53 years that they have been there, it was uninterrupted administration. However, we would like to submit that there was no reason for AirAsia to interrupt the administration, because what Ronoval is doing does not mean that we as AirAsia is relinquishing our rights to the island. If I may, can I?
I won't interrupt you. Carry on.
Second basis for our first submission that the island belongs to AirAsia is that Ronoval has insufficient proof that the St. Pierre Island belongs to it. Because in this case, the respondents have the burden at all times to prove that they have sovereignty over the island and has carried out acts of sovereign nature on or over the island. I would like to refer to the case of Cambodia and Thailand concerning the Temple of Priya Vihar in 1962. Here it stated that the burden of proof in respect of the facts and contentions on which the respective claims of the parties are based will, of course, lie on the party asserting or putting them forward.
Agent, you mentioned the Temple of Prayer case judged by the International Court of Justice. Could you please tell me the facts of this case and why this case is so relevant for your argument?
My apologies, Your Excellency. I'm unable to assist you with this matter because I believe I don't have much time left. I still have another submission to make. So,
Okay,
if I
you may
may, I would
proceed.
like to continue. So, as I mentioned, the establishment of a lighthouse and a helipad cannot be considered as having performed acts of a sovereign nature. Because in the case of Indonesia and Malaysia concerning the sovereignty over Pulau Digatan and Pulau Sipadan in 2002, the court observed that the construction of navigational aids are not normally considered manifestations of state authority. In this case, the court also referred to its judgment on the case concerning maritime delimitation and territorial questions between Qatar and Bahrain in 1994, which stated that the construction of navigational aids can be legally relevant in the case of very small islands. However, according to the statement of the facts, St. Pierre Island is not defined as a very small island. Thus, the actions taken by the respondents on that island cannot be considered as being legally relevant or is sufficient proof that they have performed acts of sovereign nature on or over the island. Thus, on behalf of AirAsia, the applicants respectfully request the court to adjudge and declare that the sovereignty of St. Pierre Island belongs to AirAsia. Moving on to the second submission of the applicants is that Imaro can intervene in the ICJ proceedings involving AirAsia and Ronaval.
Come in. All right, maybe I just want to ask you this question. I know you are short of time. What about the map, the cartographer?
Yes, Your Excellency, we at AirAsia, the cartographer is from us. So we recognize that the cartographer is correct, is right. They did draw up the map stating the clear boundaries between that the St. Pierre Island rightfully belongs to AirAsia. However, the respondents refused to recognize this fact, and it is on them to prove why they do not recognize this fact, because they are the respondents. They are asserting the claim that the island is theirs, where in fact the island belongs to AirAsia, according to the statement of the facts.
And I think if you go back and link the Temple of Priya's case, you'll find there was an issue of a map. All right, so carry on.
Thank you very much, Your Excellency. All right. Next, Imaro has the legal right to intervene in the ICJ proceedings involving AirAsia and Ronaval, pursuant to the statute of the court. Article 62 of the Statute of the Court provides that 1. Should a state consider that it has interest of a legal nature which may be affected by the decision in the case, it may submit a request to the court to be permitted to intervene. And 2. It shall be for the court to decide upon this request. As Imaro claims that its fishermen have been fishing around the island for centuries and have consistently claimed the area as theirs, they have an interest of legal nature regarding the sovereignty of St. Pierre Island. Imaro will undoubtedly be affected by the decision in the case. Hence, they may submit a request to the court to be permitted to intervene in the case, upon which the court will decide upon their request. Therefore, Imaro has satisfied the first requirement of Article 62 of the Statute of the Court to intervene in the ICJ proceedings involving AirAsia and Ronaval. We, the applicants, acknowledge the right of Imaro to intervene in the ICJ proceedings involving both parties.
What about the team Penyu? What effect has that?
Thank you very much for your question, Madam President. The effect of the Team Penyu as an international organization, they are known, they stated in the statement of the facts, that they are an international organization devoted to the conservation of endangered sea turtles. As an international organization devoted to the conservation of endangered sea turtles, it has the implication that Imaro is actively involved with the conservation of endangered sea turtles. Thus, they are they have a legal interest in this case. Does that answer your question, Madam President?
Recognition. It's actually recognition of a third party of rights. That's linked to that. All right, carry on.
Thank you. That will be the end for my submission. If I may be of no further assistance to the court, my co-agent, Ms. Divya, will proceed with her submission.
Thank you, Ms. Carmen. Moving on to my third point, that Russia is exempt from responsibility for providing renewal the damages for the HMS Gong Hippo and compensation for the loss of the ship. Under the international humanitarian law and United Nations Convention on the Law of the Sea, operations at Russia will not be liable to compensate renewal for the damages suffered by HMS Gong Hippo. Under the international humanitarian law, jus in bello regulates the conduct of forces when engaged in war or armed conflict. It is distinct from jus ad bellum, where regulates the conduct of engaging in war or armed conflict and includes the crime of aggression. Together, the jus in bello and jus ad bellum comprise the two strands of a law of wars governing all aspects international armed conflicts. The law is mandatory for nations bound of the appropriate treaties.
Agent, you mentioned, Agent, before you proceed, you mentioned this issue regarding using bello and armed conflict. I would like to know, Agent, if there is if there is any difference regarding the concept of armed conflict and act of aggression. What happened here in the present case? Are you dealing with armed conflict or a simply act of aggression?
It's a simple act of aggression, Your Excellency, because at that time, we just received threatening from Ronaldo. So it is an act of aggression.
And where we can see the definition of act of aggression in international law.
Act of aggression. Sorry, Excellency, I couldn't able to assist you further on the definition of act.
Okay, you may proceed.
Your Excellency, please to refer to Moot problem, page 7, paragraph 5. It is stated that President Harris then ordered 3 nuclear-powered submarines and 4 aircraft carriers to relocate Barents Sea. President Amarov, fearing the safety of his nation, called Russian President Mr. Putin and asked for military assistance. This declares war is prohibited. The threat or use of force against another state is also prohibited by United Nations Charter. Since 1945, war has been seen as an unacceptable means of resolving interstate disputes. As a result, threatening a nation with a military strike is against the law of humanitarian. Next,
Agent, you mentioned the prohibition of use of force. This rule, can we see exceptions to this rule? And if so, the respondent can argue one of these exceptions or the only exception? I don't know.
Sorry, Your Excellency, I couldn't able to assist you on this.
Okay,
I
you may
think
proceed.
the territorial waters and law of the sea, the demarcation of what is territorial waters, then what you mean by innocent passage, you know.
Yeah,
So these are topics that we need to address.
yes,
And
I'll be addressing it very soon, madam. So let me continue. A state is said to have undertaken an internationally wrongful conduct, which is a violation of international law when it violates any of its treaties to which signatory or when it disobeys globally accepted conventions and rules. So next, hitting naval might and demand full responsibility, which does not seem right from the perspective of United Nations Convention of the Law Sea. Sovereign waters and international waters, since all ships of all nations can enjoy the right of innocent passage through the territorial sea and archipelagic waters. A state's right To lay armed mines in waters is tempered by its obligation not to hamper the appropriate passage of foreign ships.
Agent, when you mentioned the innocent passage, is there any case judged by the International Court of Justice which dealt with the issue of innocent passage? And if so, can you use on your argument?
Sorry, Your Excellency, I didn't do a survey regarding the case, but I do have the
Kofu Channels case or something?
Yes. You may proceed, Agent, no problem, because your time is running out.
So the coastal state is entitled to suspend innocent passage to protect its national security for weapons exercises. But in such circumstances, the suspension must be temporary and only specified areas on its territorial. In other words, the right to do so is exceptional. If a coastal state lay armed mines in its territorial waters and fail to give warning or notification to vessels of another state that have rights of access or passage, it will be in the breach of its international legal obligation. Your Excellency, please to refer to Moot problem, page number 7, paragraph 5. It is stated that Arasia claimed that the ship encroached into its territorial waters. After a consistent warning given out by National Coast Guard, HMS Gong Hebo failed to pay the heat but continued its stay in that area. The National Coast Guard decided to plant a dozen of naval mines to safeguard the area from further intrusion by the naval ship. Upon leaving the area, HMS Gong Hebo collided with one of the naval mines. So, it is mentioned that the Barents Sea were not regarded as high seas, so the ship lacks legal authority to assert innocent passage, because passage is innocent so long it does not adverse to the peace, good order, or security of the coastal state. Your Excellency, please to refer to the Moot problem, page number 6, paragraph 5. It is also stated that Ronald said, even if the area was considered as high seas, the ship was not considered as high seas. The ship was exercising the right to innocent passage under international law. Under the condition, passage of foreign ship shall be considered as prejudicial to the peace, good order, or security of the coastal state if in the territorial sea it engaged in any of these following activities which renewal, threat, or use, whether renewal, threat, or use force against the sovereignty when renewal were given warning and refused to pay heed. So therefore, Republic of Renewal is not accountable for claiming that it accidentally hit mines that were set up for security purposes. Your Excellency, if there is no question regarding my third issue, I would like to submit my fourth issue. My fourth issue of this case is that Arasia is not liable to compensate Renewal for the damages inflicted to HMS Gongjini. There are currently 2 administrative regions of Arasia. First, under President Amara, where President Amara is in charge of the South, while the second would be East, where Amen United, a paramilitary organization in charge of the East. However, on the global scale, the majority of nations regarded both regions as belonging to the same nation. The group and administration of President Amara frequently engaged in intermittent acts of violence against one another, particularly near borders separating the 2 regions. Since Arasia is split between 2 regions, President Amara in the south and Amen United in the east, thus ARASEA is not liable to compensate because the actions are not responsibilities of ARASEA. The de facto boundaries of countries are defined by the area that it is governments actually able to enforce its law in and to defend against encroachments by countries that may also claim the same territory de jure.
Agent,
The
so
Convention on International, the International Convention on State Responsibility. Is there anything responsibility for international wrong? Is there any provision that you can cite?
Russia is currently following de facto and de jure, madam, and
because is this can you look at Article 10? I mean, I'm giving you, it's even if it's de facto de jure, it's actually third party recognition on the state, whether they recognize it, as the party in effect power, having legal recognition and having factual control, right? But that is maybe there's a case UK against where they recognize certain where nationalities recognize each other. Now this one, you have insurgents, or basically control over a certain within the region, certain parties, who are control over certain portions of the regions. Would this come under insurrectional or other movement under Article 10? It's not part of your pleadings.
I'm sorry, Your Excellency, I couldn't able to assist you on that matter. I think I shall move on to my.
Okay, carry on.
So the following actions, though not all of them are considered as acts of aggressions under UN General Assembly resolution, regardless of whether it's a declaration of war had been made by any military occupations, invasions, or attack of the territory by another state, or by an armed force, regardless of how transient, brought about such invasion, attack, or another annexation by the use of force of the state armed force bombing another state territory of portion, the use of any weapon by a state against the territory of another state, or use of any force, state's ports or coastline being blocked by the military forces of another state. This definition is based on three criteria, which is the act of aggression must be perpetrated by the state, and second would be that it implies the use of armed force, and third would be it must reach a level of sufficient gravity in order to be qualified as such a Security Council. Thus, the paramilitary organizations aimed at attack is not responsible by ARASEA. For foregoing reasons, I would respectfully request that the court find a favor of Republic Renewal on violation of acts of aggression under UN General Assembly resolution does not apply for ARASEA. Thank you, Your Excellency. I please the court.
Thank you.
I'm sorry. Respondent team 001. We will start with your first agent. Your time starts now.
Madam President and Mr. President, Your Excellency, may it please this court. My name is Kishan Kumar and I appear for the respondent, the Republic of Renawon, along with my co-agent, Martin Luke. I will be speaking first for 70 minutes and my co-agent will speak second for 70 minutes, and we reserve 1 minute for rebuttal. Today, the respondent has 4 submissions to make, in which I will deal with the first and second issue, while my co-agent will deal with the third and the fourth issue. First issue is whether the Senpe Island belongs to Arasia or Runawal. Second issue is whether Imaru can intervene in the ICJ proceedings involving Arasia and Runawal. Third and the last issue is whether Arasia is liable to compensate the damage suffered by our 2 naval ships, namely HMS Gompipo and HMS Genie. Unless there is any preliminary question, I will now begin with my submissions proper. Your Excellency, we submit that the Senpe Island belongs to our government because our government has acquired the island through prescription for 2 grounds. First, possession of our government has actual exercise of sovereignty. Second, possession of our government is peaceful and uninterrupted. Turning to our first ground, or the first issue, Your Excellency, possession of our government has actual exercise of sovereignty because there is an intention to act as sovereign by our government on the Senpe Island. Your Excellency, in Clipperton Island case in 1931 and Eastern Greenland case in 1933, Scott emphasized that an actual display of sovereignty must be accompanied by an intention to act as sovereign. Therefore, Your Excellency, the administration of our government's navy has manifested the intention to act as sovereign and displayed such an authority when our government defend our territorial sea from the further encroachment of the applicant's fishermen. It is also emphasized in Anglo-Norwegian fisheries case in 1951 that the independent activity of private individuals is of little value unless it can be shown that they have acted in pursuance of a license or some other authority received from their government. Your Excellency, the applicant has only emphasized about the alleged fishing activities. The applicant's fishing activities cannot be regarded as an intention to act as sovereign because it is an independent activity of the fishermen, and in the statement of facts, there's also no evidence that it is pursuant under the legislative or the judicial authority of the applicant.
On the statement of facts, Kishan, it's
Yes.
only stated 12th of October 2021 that there was a chasing away of AirAsia's fishermen. That created the dispute. That's the timing of the dispute. So if there was customary fishing of this area even prior to this, during these 53 years, and there was no assertion of a territory, right, during that period, you realize that you have the burden of proof now, right? Because
Yeah.
it's Article 3 is,
Yes,
it's 9 nautical within the territorial landscape of the Article 3 of the UNCLOS. So you have the burden, right? So you have to show that you actually exercise sovereignty and had intention. And so the dispute only occurred in 2021, seemingly, right? But even it doesn't, 53 years was there allowing other parties to access the territorial waters, which I don't know which territory. Right now you have to say it's your territory, but it would seem that other parties also have basically, the intervening party has got support from third parties, and now you have AirAsia and all these other parties claiming excess of fishing and etc. If it's territorial, right, what would be the sovereignty kind of owner intention there? That's my, curious.
Your Excellency, could you rephrase the question? Yeah.
Okay, what will be your display of acts of sovereignty as opposed to ownership?
Oh, Your Excellency, there is also establishment of the lighthouse and helipad, where in the case concerning the sovereignty of the Pulau Batu Putih, the court awarded Pulau Batu Putih to Singapore, which has the actual exercise of sovereignty, possession of literary sovereign, and there was also an absence of protests of Malaysia against the Singapore Acts. And also one of the sovereign activities that displayed by Singapore is the establishment and maintaining of the Hornsberg Lighthouse. Sorry.
Yeah, I agree with you. It's also the lighthouse, but it's not solely on that, because it was not just the lack of protest, but Malaysia actually had done certain acts that basically indicated, gave recognition to the sovereignty of Singapore, right? So there were acts beyond just establishment of helipad or lighthouse. In your case, what would be the additional? It's not just the physical 2 items. Is there anything additional? What about the chart and other issues related? There's a chart that they relied on. The cartographer at para 8 of page 8.
Your Excellency, there is also sending of the note verbal to Arisia regarding this matter, Your Excellency. Other than the establishment of lighthouse and the establishment of the helipad. But Your Excellency, the applicant has only displayed the fishing practice as their only sovereign activities, Your Excellency.
The applicant is also de facto, I mean, they have Article 3 from the territorial waters, the island. They have that in their favor. And you are applying prescription.
Yeah.
So prescription, you cannot have a contrary act by the, what do you call it, the existing sovereign. So, and then the time frame for prescription, in addition to the, do you have anything that says the time frame that that would be arguable to be considered sufficient in addition to acts of sovereign exercise?
I can see in the statement of facts itself, it's in paragraph 6, it states that our government has claimed that sovereignty of the Sanpe Island on the basis of the uninterrupted administration, Your Excellency, because there were no any objection from the former sovereign Arisia for 53 years, for the last 53 years. And they have also not established any sovereign activities that can be taken into account, Your Excellency.
In the British Guiana's case, I think there was an agreed 50-year prescription, but that was by agreement,
Yeah, I agree.
Yeah, that by agreement. So that's the British Guiana's case, maybe. Anyways, carry on. Yeah.
Turning to our second ground of the first issue, Your Excellency, we submit that possession of our government is peaceful and uninterrupted. In Kasikili and Sedudu Island case in 1991 involving the Botswana and Namibia parties, the parties agreed that one of the criteria for the international law to recognize implicit prescription is the possession is peaceful and uninterrupted. In Camisel arbitration in 1963, the claim by US claiming the Mexican territory failed as Mexico had made a number of protests to the US, as a result of which a convention had been signed in an attempt to settle the rights of the two nations. Thus, the diplomatic protests by Mexico prevented title rising by prescription. Your Excellency, Sanpe Island is located 12 nautical miles from Arisia, and according to the Article 3 of United Nations Convention on Law of the Sea, every state has the right to establish the breadth of its territory up to limit not exceeding 12 nautical miles. The applicant also has the right to establish its territory measurement, Your Excellency, but the applicant also...
Agent, before you proceed, I will repeat one question that I mentioned to the agent for the applicant. I will repeat for you. This rule concerning that you mentioned from UNCLOS, do you understand that this rule is a customary law?
Yes, Your Excellency.
So where we can see the opinio juris and the state practice of this customary law?
But Excellency, under Article 38 of the International Court of Justice Statute, customary international law is defined as evidence of a general practice accepted as law, Your Excellency, and also as there's no evidence that the fishing practice alleged by the applicant is obtained from its legislation or decisions in domestic case, Your Excellency, or its activities on the international stage, Your Excellency.
So
And
are you saying that the customary law without the opinio juris, is that right?
Yeah.
So there is no customary law because the two main elements of a customary law are, according to the jurisprudence of International Court of Justice, are opinio juris and the state practice. There must be these two elements. So are you stating here before this court that there is no opinio juris? Is that right?
Yeah.
So there is no customary law.
Would that be in your favor?
Your Excellency, could you rephrase the question?
Okay. Okay. My question is, I'm asking you if this rule that you mentioned from UNCUS is a customary law. And after that, I asked you where we can see these two elements of the customary law. And you mentioned to me there is no evidence of practice under the legislation. So are you saying that there is no opinio juris? So my question is, it is a customary law or it's not a customary law?
Your Excellency, I believe that it's not a customary law, Your Excellency, because as stated in the Ashram case in 1950 by the ICJ, a customary rule must be in accordance with the constant and uniform usage practiced by the state in question. But Your Excellency, the chasing away was occurred only. It is in the statement of facts itself. It's clearly stated only once it happens. The chasing away of the RSS fishermen from our territorial sea, Your Excellency.
Okay, you may proceed.
Yeah, okay. Sorry, Excellency. The applicant, as the former sovereign, has failed to protest against our government's administration over the Sanpe Island for the last 53 years. The absence of protest by the applicant is contrary to the Mexico's Act, where it carried out diplomatic protests against US. Therefore, Your Excellency, the absence of applicant's protests reflected applicant's acquiescence to give up its sovereign right over the island. And also, it is in Temple of Preah Vihar case in 1992, Thailand had acquiesced for many years by failing to object to a map that had been drawn by a mixed commission in 1980, showing the temple as being on the Cambodian side of the border. And Thailand was thus stopped from denying the fact which was established by the map, Your Excellency. Therefore, acquiescence of the applicant give rise to estoppel in which the applicant should be stopped from denying sovereignty of the Sanpe Island, Your Excellency. Your Excellency, I will now move to our second submission that IMARO cannot intervene in the ICJ proceedings involving Arasia and Ronawol because IMARO has not established the existence of an interest of legal nature justifying the intervention. According to Article 62 of Statute of the International Court of Justice, intervention is for the purpose of protecting a state's interest of a legal nature that might be affected by decision in an existing case. In the judgments concerning the applications for permission to intervene submitted respectively by Honduras and Costa Rica, the court clarified that under Article 62, the state seeking to intervene as a non-party does not have to establish that one of its rights may be affected. It is sufficient that the state to prove that its interests of legal nature may be affected. Similarly,
you mentioned,
yes.
Before you proceed, you mentioned this case regarding Nicaragua against Costa Rica.
Yeah.
Could you please tell me the facts of this case briefly and how this case is so important for your argument?
Actually, you could actually use the Pulau Litikan case, which is also relating to intervention.
Yes, Sorry, Your Excellency, I could not assist this court regarding this matter.
Okay, you may proceed.
Similarly, Imaro seeking to intervene has only established that its fishing rights may be affected. Fishing rights is a general interest, and Imaro also has failed to prove that its interests of legal nature may be affected, Your Excellency. It is also emphasized in the territorial and maritime dispute application by Honduras for permission to intervene that the legal interest is defined by the court as a real and concrete claim of that state seeking to intervene and based on law. And also, according to Judge at Hogaja, the interests of a legal nature must exist according to the international law, Your Excellency. Therefore, we submit that the third state Imaro does not have any legal interest to intervene as a non-party in the current circumstances, Your Excellency.
Do they have any footing? Do they have any footing to claim territorial sovereignty here? Do they have a ground?
Yeah, it's fishing. No,
What do they allege actually? What are they trying to say? They're just doing fishing around that area. Does that make them having legal interest? Is that a sufficient legal interest for staking a claim on the territory?
No, Your Excellency, they only has established fishing rights, and it is also not in the statement of facts. It's not clear whether it is done out of legal obligations, Your Excellency, or is it under their jurisdiction, or is it under their legislative or judicial authority of the third state claiming the ownership. And they've only stated in the website, Your Excellency, about that they have consistently claimed their claim by their country over the Senpei Island, and also on the basis of the fishing rights, Your Excellency.
So just now you mentioned, but I think there is also under the intervention rules that they are required to precise object of intervention, to state a precise object of intervention. So whether that has been satisfied. Okay.
Yes, Your Excellency.
Okay.
And also, Your Excellency, in the land, island, and maritime frontier dispute involving El Salvador and Honduras, it is emphasized that the state seeking to intervene has to show in what way that interests may be affected. And it is also not clear whether fishing rights will be affected by the decision case, Your Excellency. Madam President and Mr. President, Your Excellency, if I can be of no assistance to this court, my co-agent will proceed with our third and fourth issue. Thank you very much, Your Excellency. May it please this court.
Thank you.
Before I begin with my submission, am I audible to all of you?
Yes, Martin. Yeah.
Thank you. Good morning, Madam President, Your Excellencies, may it please the court. My name is Martin Luke, and I'll be assisting this court with the third and fourth issues. The third, whether RSA is liable to compensate Ronawal for the damage suffered by HMS Gong Hippo, and fourth, whether RSA is liable to compensate HMS Gong Ji. Turning to the third issue, Your Excellencies, we submit that the applicant is liable to compensate our government for the damage suffered by our naval ship, the HMS Gong Hippo, for two grounds. Firstly, the HMS Gong Hippo was engaged in innocent passage, and secondly, the applicant's act of planting naval mines is not justified by self-defense. Your Excellencies, HMS Gong Hippo was engaged in innocent passage through RSS territorial sea. This is permitted under Article 17, right of innocent passage, where ships of all states, whether coastal or landlocked, enjoy the right of innocent passage through the territorial sea. Your Excellencies, in this current circumstance,
you're conceding that it's not international waters, is it?
It is an international water because it is known in the United Charter, Your Excellencies.
So, Martin, how do you determine international water?
Your Excellency, I could not assist you with the relevant information, Your Excellencies.
Okay, for us to say the ship is going through international water, then there should be no issue of innocent passage at all, because international water is for every state to use. Unless we enter into the territorial sea or the EZ, then you may talk about innocent passage, especially in the territorial sea, right? So we got to identify before we talk about exercising the rights of innocent passage itself, in which maritime zone that we are passing through, right? Yep.
Thank you for this.
Yeah.
Yes,
Yes, please proceed.
Thank you for the assistance, Your Excellencies. Apologize for the earlier explanation. We are indeed in the international water because this is recognized under the Innocent Passage in United Nations Convention Law of Seas, where in Article 17, it is clearly stated that all states enjoy the right of innocent passage, and therefore we contended that our naval ship indeed engaged in innocent passage. According to United Nations Convention of Seas, this passage should be innocent as long it is not prejudicial to the peace, good order, and security of the coastal state. The non-innocent passage asserted by the applicant should prove this proof of the non-innocence, Your Excellencies. Furthermore, in Corfu Channel, this court found that the passage may be innocent even where the coastal state asserts that ships in its territorial sea are carrying out political missions, observing and reporting on the coastal state's defense. Here, Your Excellencies, we would like to emphasize that not all intelligence is intended to have the objective of prejudicing international peace and security.
Agent, you mentioned the Corfu Channel case. Could you please tell me why this case is so relevant for your argument? Because this case is from like more than 70 years ago. Do you have why this case so at the beginning of the International Court of Justice? Why this case is so relevant for your argument? Is there any other case law more recent from the ICJ regarding also the innocent passage?
Your Excellencies, the reason why we took this case is that it is in regard with our current circumstances, where this case concern about two states which where this case yes, it's about mines concerning about two claims about United Kingdom and Albania. Therefore, in this case, the laying of mines could not have been laid without the knowledge of Albanian's state. Therefore, in this court, it is concluded that the Albanian government has authorized the laying of mines, and therefore, this is why we use this case in our submission, Your Excellencies. Moving on.
One more thing, Agent. Don't you think that even in Kafu Channel case itself, it was based on assumption, presumption, so they could not prove. It's sort of like your laying mine. It's sort of like a crime if we talk about at the level of domestic law, right? So can we just establish a case simply based on the assumption? I'm noted that Kafu Channel case was the first case before ICJ, which was heavily reliant on the assumption. Yeah, maybe they may have the intel, yeah, but then still, and in a court of law, we still have to prove. So would that make your argument so strong, even to rely on the Kafu Channel case itself? Or whereas in a court of law, you got to prove sort of like beyond reasonable doubt in this case. What would be your view? Yeah, please.
Your Excellencies, in this case, the court concluded that the laying of armed mines could not have been accomplished without the knowledge of Albania. It is
Yes, how are we
Albania's-
going to prove that? Yes, how are we going to prove that they have the knowledge?
Your Excellencies,
Is this issue an issue in this case? The mine are they admitting laying the mines here on the facts?
in regard with the statement of facts, they are the applicant have laid the armed mines without informing to our vessel. They have informed earlier, and after informing and with the constant warning, after that they have planted those naval mines. This is similar in this Corfu case where Albanian does not notify this British.
Sorry, Martin. In Kofu's case, the issue was Albanian said that they didn't lay the mines. Okay, Albanian disputed that they actually lay the mines, but in the court judgment, in the majority judgment, there was a dissenting judgment where the court said that basically based on their expert evidence that they sent to Albania, that the mines would not have been, the people on Albania, standing on the land of Albania, could see if there was anyone who's going to lay the mines in that particular territorial waters. So there, the courts basically relied on that evidence, right, to basically say that the act, the laying of mines was responsibility of Albania. The question here is, on the facts of this case, is there an issue as to who laid the mines?
To who laid the mines is it is clearly stated.
Yeah.
Your Excellency, the naval mines were being planted by the applicant to safeguard its area from further encroachment of our naval
There's no
street.
dispute that they admit laying the mines. Now the question is, were they justified in terms of could they rely on any of the exceptions if it's territorial waters? If it's not territorial waters, then it will be international waters, right? So
yes, Your Excellencies, I understand your concern, but however, we would like to submit that before such act was projected by the applicant, there's certain measures that needed to be taken. Laying naval mines is constituted as an use of force. Therefore, such measures need to be notified to the Security Council first. And that's why we are infirm that such act of planting naval mines does not justify self-defense, but an intention to damage our naval ship, Madam President. Madam President and Your Excellencies, in the oil platform, the court found that a series of minor attacks was not sufficient to justify for self-defense. In this current case, Arisia suffered no armed attack, which will not give rise to the right of self-defense.
Agent, before you proceed, you mentioned the oil platforms case and you mentioned also the armed attack. Here in the present case, are you arguing that there was an armed attack or there was an act of aggression or both of them? Could you please clarify to me these concepts?
Your Excellencies, there is no armed attack occurred in the first place, and the applicant may argue that the existence of our naval ship may show a form of threat to their coastal state, and without informing to the Security Council for to plant the naval mines, that does not constitute or justify a self-defense, because if they were to lay down this naval mines, which constitute as use of force. Therefore, they should notify the Security Council first, so that they will evaluate and take necessary and proportional measures, Your Excellencies.
Agent, so you mentioned these necessary measures and proportionary measures. Are there any objective criteria to establish necessity and proportionality in this case?
Can you rephrase that, Your Excellencies?
Yes, you mentioned, for instance, there must be the observance of necessity and proportionality for the use of force. My question is, are there any objective criteria to establish what is a necessary measure and what is a proportional measure for the use of force?
Your Excellencies, in regard with these two key points, necessity means that the threat must be instant, overwhelming, and leaving no choice of means and no moment for deliberation. Whilst proportionality means is respond to an armed attack and must be reflect to the scope, nature, and gravity of the attack. Here, we would like to submit that there is no armed attack occurred, and such such act of planting naval mines by the applicant is not proportionate to the current situation because there's no armed attack.
Can you also submit that the fact that it's a naval ship, not an army ship, is, you know, the nature of the ship itself?
Yes, Your
Would that be
Excellency.
relevant? Would that be relevant? Like Corfu Channel's case, the facts on that facts is also there's some distinction. In this case, the ship itself was a naval ship, right? So you take from the identify the facts that will support you. Okay, Martin, don't have to think too much about it.
Your Excellency, I apologize for this.
Agent, before you proceed, you give a very interesting definition of necessity and proportionality. Very interesting. Did you base on what source of law this definition that you mentioned to us?
Sure, Your Excellencies. These two key points has been laid out in the case of Caroline incident, Your Excellencies, where the United States Secretary Daniel Webster proposed these key points because the
Caroline case. The
Yes.
Caroline case is a very old case. Is there any other recent case from the ICJ or other international tribunal regarding the same definition that you mentioned to us right now?
Your Excellency, please, I'm apologize. I'm unable to assist this court with the new cases.
No problem. You may proceed.
Your Excellencies, I will now move to the respondent fault submission, which is ILSA liable to compensate Rona Wall for the damage suffered by HMS Gongjini. Our government submit that ILSA attack on the HMS Gongjini was an unlawful use of force amounting to aggression. For the first ground, for this submission, ILSA is obligated to make reparation. We submit that states, in this case, the applicant, has committed an international wrongful act, and therefore it's obligated to make full reparation for the injury caused by the act. The Amen United attack on the HMS Gongjini has contributed product of internationally wrongful act. Therefore, ILSA must make reparation to account for all the consequences for this illegal act. Your Excellencies, in assessing whether ILSA's attack on the HMS Gongjini constitute an armed attack, first, the court should identify whether the force was used against the territory of another state. Second, the force was a sufficient character, gravity, and scale to constitute an armed attack. Third, the act was not a mistake, but committed with an intent to violate another state's sovereignty. The attack on the HMS Gongjini was a clear violation of Rona Wall sovereignty, as the ship was navigating through the territorial sea of Ronawal. Clearly, ISS attack on the naval ship, which resulted 6 casualties, carries sufficient gravity, and conducting hostilities against a naval ship during peacetime or during armed conflict constitute an armed attack. Finally, the attack of the ship lasted about 15 minutes, and the group has used various weapons such as assault rifles, machine guns, and rocket launchers. Therefore, it was an act with the intent to conduct a military strike against the Ronawal's territory sea. To conclude our fourth issue, we submit that ISA is liable to compensate Ronawal for the damage suffered by HMS Gongjini for internationally unlawful act, and AirAsia attack on the HMS Gongjini was an unlawful use of force amounting to aggression. Mr. President, Your Excellencies, we therefore pray this Honorable Court to adjudge and declare that the St. Pierre Island belongs to Ronawal. The court will not allow Imaro to intervene in the ICJ proceedings. The applicant is liable to compensate Ronawal for the damage suffered by HMS Gonghipo and Gongjini. If I may be no further assistance to this court, this concludes the respondent's submission. Thank you. May it please this court.
Martin, I would just like to ask this question, which I also asked the applicants just now. I know Article 10 of the International Law Commission on international responsibilities of states for internationally wrongful acts, right? Now, in that particular provision, right, it provides that it refers to insurrectional movement. Would the Amman United be considered as, if they will be considered as insurrectional movement, you know, the liability of the state of AirAsia can be negated? Is, you know, in that situation, would what would your comment be, you know, on that particular provision?
Madam President, we are fully aware that the facts has clearly stated that they are the RSA has been divided into 2 administrative areas, where the east has been controlled by the paramilitary group and the south has been controlled by President Amara. In Article 10, we submit that the armed group may hold territory in a non-international armed conflict between an armed group and a state. So both parties may be capable of bearing responsibility under international law. Also, Madam President, the territorial sovereignty of the, if I may bring the your attention to the special reporter's report on Afghanistan in 1989, the territorial sovereignty of the Afghan government is not fully effective, since some provinces of the Afghanistan are totally or partially in the hands of traditional forces. Even if it's in the hands of traditional forces, it is possible that these 2 different entities could address for different or share conduct in the same area. And therefore, Amman United is linked with ARISA, your Madam President. Your Excellencies, if there's no, if you may need no further assistance to the court, this has concluded the respondent submission. Thank you.
Thank you, Martin.
Thank you, Team 001. And now we will proceed to a rebuttal and rebuttal session. 5 minutes for each team, starting with Team 005. Team 005, your 5 minutes starts now.
Your Excellency, I would like to rebut 2 points of my opponent's team. First, I please to refer to Moot problem, page number 6, paragraph 5. paragraph 4. It is stated that Ronald said even if the area was not considered as high seas, the ship was exercising the right to innocent passage under international law, which claims that Ronald itself not sure that Barents Sea was high seas. The Barents Sea were not regarded as high seas. High seas in maritime law are considered as all part of the marsal waters surrounding the globe that are not part of territorial sea, and Barents Sea is considered as territorial sea for Eurasia. Your Excellency, please also do refer to Moot problem, page number 7, paragraph 5. Our government already won the HMS Kong Hippo, but the ship failed to pay heed. So even if they were unsure if the area was the high sea, we have already won them multiple times. Russia is acting in compliance with the United Nations Convention law of the sea, and the naval mine were planted as a security purpose and not intended to damage the ship.
Sorry, Tivia. It does say at paragraph 5, the National Coast Guard decided to plant a dozen mines in the area to safeguard. Yeah, so it was planted, but then what provision are you relying on to substantiate your right to plant that mines? Can you refer to a specific case or a specific provision?
We are relying on United Nations Convention law of the sea, but the provision I am not sure regarding it.
You have a right to have there is certain limitations on the use of territorial sea, but there is also certain limitations as to how you can exercise that rights. So, so the relevant provisions are within, stated. So you need to specify if you want to say that you have a right to plant mines, yeah, and it's a naval ship, and the threat, and so those things have to come into play, not just rebuttal on just saying you have a right.
Yours Excellency, thanks for the question. We are referring to United Nations Convention Law of the Sea at Article number 21, where the laws and regulation of the coastal state relating to innocent passage. So naval mines can be planted in territorial sea if the safety of the navigation and regulation maritime traffic were revoked, Madam. So I would like to move into my second point to reboot that Russia's attacks against Gongjini and Russia is not responsible for the attack because the responsibility goes to Yemen United, which is the paramilitary group of another part of Russia. Yours Excellency, please to refer to Moot problem page 9, paragraph 12, which is on 24th of December 2021. Ronald launched a concerted attack on Russia's territory. Hundreds of military assets had been mobilized for such purpose. The attack had destroyed various military and civilian structures of Russia, including important harbors, oil platforms, and airport. It had also killed a number of persons, including citizens of foreign countries. The act was done by a Yemen paramilitary group. Such attacks are not under the control of Russia, and Russia should not be liable for the responsibility. Republic of Ronald is against the humanitarian law and international law of conduct military. The self-defense they did was the self-defense that been conducted by Yemen paramilitary group was more drastic than ours. Thank you.
Refer to para 12, yeah. Para 12 happened on the 24th of December 2021 after all the prior attacks, right?
Yes,
Is
madam.
para 12 now relevant to the matters, the issues before the court now? Is it now an action that AirAsia is bringing against Renovo before this court today?
Sorry, madam, can you rephrase
Is
the
para
question?
12 an issue before the court today?
No, that is not.
It's not a provocation also because it happens, the timeline is, it happened after everything.
Yes.
So you cannot use it as a, you cannot use it as a defense, self-defense, because the timeline was later, right? And it's not a matter that AirAsia is claiming against Ronaldo in this court. Okay. Divya, you understand what I'm saying, right? It's,
Thank you, madam.
welcome.
Thank you, Team 005. And now we're going to start with Mr. rebuttal. Team 001, your 5 minutes starts now.
Good morning. May it please this court. I will now address one point as a rebuttal in regard with the constant warning that has been given by the applicant. In regards to the consistent warning, yes, we are fully aware that the applicant has given the consistent warning to our naval ship from sailing further its territorial sea. However, they do not warn us about the naval mines being planted because the applicant warned the action before planting the naval mines. However, I would like to bring your attention to the case of Carrefour Channel, where the court concluded that if any state, which is Albania, laid out armed mines could not have been accomplished without the knowledge of Albania. And it was Albania's responsibility to notify ships proceeding through its straits of the danger of mines. Therefore, nothing was attempted by Albania to prevent the explosion and the omission of Albania's international responsibility. And that's conclude our rebuttal. May it please the court.
Actually, Martin, I don't see why you need to rebut that because in this particular case, the mine was planted. Albania's case, it was an issue as to Albania was responsible. And the courts actually put that responsibility on Albania for an omission, rather than an act. So whether the courts were, but because the courts say they had that area within their site, but in your case, it's already admitted.
And yes, Your Excellencies, I am unable to assist you regarding this matter.
Agent, before just to clarify to me, so you won't do this rebuttal of the other points raised by the agent for the applicant at this moment? You only address this issue regarding your point that you
Mines.
mentioned?
Sorry, Your Excellency, can you repeat the question?
Yes, just to clarify one question. Your only issue addressed here in the rebuttal is that point that you mentioned, this right of communication and the right to notify regarding the mines. So you won't use this moment to do the rebuttal of the other points addressed by the agent for the applicant that has already that has just done right now on the rebuttal. I took note issues like IHL violations and other points that she mentioned just right now. So you won't do the rebuttal of these points. Is that right?
No, Your Excellencies.
Okay, I
Okay.
just want to get both respondent and claimant, as far as the intervention is concerned, are you all allowing, agreeing to the intervention, or are you all rejecting it? The position, of the intervening party here. Imaro, you didn't state your position. Was it clear, or didn't your position on the intervention of Imaro? Should they be allowed to intervene?
Imaro doesn't. We submit that Imaro should not interfere the proceeding of ICJ, Your Excellencies.
On the grounds that there's no legal interest, or on the grounds that
yes, Your Excellencies. Thank you for the assistance. The applicant have not yet proved that they have constituted such legal interest. However, we submit that the 53 years of establishment has constituted a silence of approval from the applicant. After the 53 years, out of nowhere, this applicant has protested that the island belongs to theirs. Therefore, they should indeed prove the legal interest that occurred in this case, Your Excellencies. Your Excellency, that's from the respondent.
Okay. Thank you.
Alright, thank you, judges and both applicant respondent team. Any additional comments or questions from the judges?
Thank you, Aisha. None from me. None from me.
Thank you. Vice Albany,
Oh,
do you have any additional comments?
no comments. Thank you.
Alright, thank you. Professor Muhammad Hassan, do you have any additional comments?
No comment, no question.
Thank you. Okay, judges and both team. With that concludes final round oral submission. I would like to remind all of the judges to email us the score sheet as soon as the session ends. As a member of the ILSA committee, I would like to thank Association Professor Dr. Usharani Balasingam, Professor Alvani Trinde, and Association Professor Dr. Muhammad Hassan Ahmad for sitting down with us as judges in this competition. Thank you all, and have a good day.
So Aisha, I just want to confirm. So basically, we don't need to confer, but we just email you the marks.
Yep. Yep. And our team will calculate all of your score sheet, and then tonight we're going to announce who's the winner.
So we just need to fill out the form and send to you, lah. That's all.
Yep.
Okay. There's
That's
no. Okay. So you do individually. I thought you have a session, but
Yeah.
it's fine. All right. Okay then. Nice meeting everyone. Thank you very much for the opportunity. Bye.
Thank
you very much.
Judge,
Bye.
Thank you very much, everyone.
don't forget about the email.
Oh yes, I will ask the organization for your email, and I will contact you.
Mine is just usha@um.edu.my.
I can text the organization to our changing of context.
All right, no problem. No, because I need something. I just need a little bit of your thing. Monday, I would like to see her. So no problem. Thank you, everyone.
Thank you.
Prof. Muhammad Hassan, thank you.
Yeah,
thank
bye,
you,
Dr.
judges.
Usha.
And Kishan Kumar,
Nice to meet
Jamil, Martin, Timashini. I think there's one more person who's not gone already. And Aisha. All right, thanks.
Thank
See
you
you
so
all.
much.
Congratulations for
Bye.
both teams.
Now.
Bye, everyone.
I'll meet in front of you. Bye. Take care.
Bye-bye.
Bye bye.